Your property manager just cost you $14,000. Not in fees, you knew about the fees, in decisions you didn't know they were making. That's the number one thing landlords who fire their property managers tell me after the fact. Not that the fees were too high, not that they were hard to reach, but that by the time they found out something had gone wrong, the damage was already done. The lease had been signed, the repair had been authorized, the tenant had been approved, and nobody called you first. If you have a property manager right now, what I'm about to tell you is going to be uncomfortable, and if you've been thinking about hiring one, you need to hear this before you sign that management agreement. The pitch is seductive. Hand over your keys, collect your check, live your life. That's what property management companies sell you. And for a certain type of investor, someone who owns 30 units across 3 states, it might actually work, but you're not that person. You own 2 to 20 units in California, probably within driving distance of your home, and the math on that deal is not what they told you. Here's what the fee structure actually looks like. The average property management fee in California runs 8 to 12% of gross monthly rent. On a $2,200 unit, that's $176 to $264 per month before anything else. Then add the leasing fee, typically 1 month's rent every time they place a tenant. Add maintenance markups, which in California commonly run 10 to 15% on top of the contractor's invoice. Add lease renewal fees, which some companies charge even when the same tenant just signs another year. By the time you're done, you're not paying 8%. You're paying closer to 15 to 20% of your gross revenue every year to someone whose financial incentives don't fully align with yours. But here's the real problem, and this is the part that doesn't show up on the fee schedule. Passive doesn't mean uninvolved. It means uninformed. There's a difference between delegating decisions and being cut out of them. And in California, where tenant rights law is among the most complex in the country, being uninformed about what's happening in your own property is not just expensive, it's legally dangerous. Let me tell you about a landlord named Marcus. He owns 4 single-family rentals in the Inland Empire. He hired a property management company in 2022 because he was burned out. He was tired of 11 p.m. maintenance calls, tired of chasing late rent, tired of all of it. So he signed a management agreement, took a step back, and let someone else handle it. 14 months later, he gets a letter from a tenant's attorney. Turns out the property manager had accepted partial rent payments for 3 consecutive months without issuing proper notices, which under California law effectively waived Marcus's right to pursue eviction based on those missed amounts. The manager knew the tenant, liked the tenant, thought the tenant would catch up. They were probably right. But they made a judgment call that wasn't theirs to make, and it wasn't documented properly. Marcus ended up in a $9,000 settlement to get the tenant out without a protracted court process. Now here's where it gets interesting. When Marcus went back through his owner's statements, he found maintenance charges he didn't recognize. A $400 invoice from a vendor he'd never heard of for preventative HVAC servicing on a unit where the HVAC was practically new. He called the vendor. The vendor had no record of the job. He called the property manager. They said they'd look into it. He never got an answer. Marcus is not an outlier. He's the pattern. And he's exactly who is driving the wave of landlords firing their property managers right now. Here's something most property managers won't explain to you up front. In California, the property owner is the principal. The property manager is your agent. That means you are legally responsible for what they do in your name, even when you didn't know they were doing it. Under California Civil Code and agency law, if your property manager violates a tenant's rights, fails to make required disclosures, mishandles a security deposit, or retaliates against a tenant for a habitability complaint, you can be named in the lawsuit right alongside them. Your property manager carries errors and omissions insurance, but that policy protects them, not you. Your homeowner's policy or landlord policy may have gaps, especially if the management company's actions are characterized as intentional rather than negligent. California's security deposit law under Civil Code Section 1950.5 is a perfect example. The law requires itemized accounting within 21 days of a tenant vacating. If your property manager misses that deadline, or provides an itemization that doesn't hold up, the tenant can sue for up to twice the deposit amount as a penalty. That's in addition to the deposit itself. And if a court finds the violation was in bad faith, they can add attorney's fees on top. One missed deadline, one careless itemization, potentially thousands of dollars out of your pocket. But wait, there's a catch. The same complexity of California law that creates this liability is also the reason self-managing landlords sometimes avoid it in the first place. The question isn't whether California law is complicated. It is. The question is whether paying a property manager is actually solving the legal risk problem, or just shifting the locus of the mistake. For years, the case against self-management was simple. The tasks were time-consuming, the legal landscape was confusing, and the tools available to independent landlords were consumer-grade at best. You'd have a spreadsheet, maybe a basic rent collection app, and a folder full of lease templates you weren't sure were current. That's changing, and it's changing fast enough that 2026 is genuinely different from 2020. The wave of AI-assisted property management tools, lease drafting with jurisdiction-specific compliance checks, automated rent collection with late fee logic built in, maintenance request tracking with documented response timestamps, these are no longer enterprise products that only large operators can afford. They're increasingly accessible to someone who owns 3 units and manages from their phone. Think about what documentation and response time actually mean in California. If a tenant makes a habitability complaint, and you can show a time-stamped digital work order, a contractor communication log, and a completed repair confirmation within a reasonable time frame, you've built a legal record that most property managers can't produce on demand. You've demonstrated habitability due diligence, you've protected yourself, and you did it without paying someone else a monthly fee to maybe do it for you. Consider the math on a single unit. At $2,200 per month, a 10% management fee plus 1 leasing fee per year averages out to roughly $4,840 annually. That's money you could spend on tools, on professional consultation, on an attorney to review your lease once a year, and still come out ahead, while knowing everything that happens in your property in real time. If you're thinking about making this move, do it right. Rushing the exit is how you create the very problems you're trying to avoid. Start with your management agreement. Read the termination clause before you do anything else. Most California property management agreements require 30 to 90 days written notice, and some have early termination fees if you're inside a contract term. Identify your exit window and put your notice in writing. Certified mail, return receipt requested. This creates a paper trail that matters if they try to claim you violated the agreement. Request a full accounting before the transition date. You want every owner statement, every maintenance invoice, every vendor contact, and every tenant communication for the entire period of management. California law gives you the right to your own business records. Some property managers will be cooperative. Some will drag their feet. Give yourself time to follow up. Don't transfer tenant security deposits without verifying the amounts. Cross-check what the manager shows as the deposit balance against what each tenant actually paid at move-in. Discrepancies happen. You're responsible for the correct amount regardless of what the manager claims to be holding. Walk your properties before the transition is complete. Not to be suspicious, to be informed. You need to see the actual condition of the units you're taking back. If there's deferred maintenance that was never reported to you, you need to know before you're standing in front of a tenant who's been complaining about it for 6 months. And get your legal documents current before your first day as the direct point of contact. Your lease, your rent increase notices, your habitability disclosure. All of it needs to reflect current California law as of the date you take over. Laws change. The rent control landscape in California has shifted repeatedly in recent years. What was compliant in a lease signed 2 years ago may not be compliant today. Here's what you need to walk away with. Property management fees are not just the percentage on the contract, they're the leasing fees, the maintenance markups, and the renewal charges that stack on top of it. You are legally liable for what your property manager does in your name, even decisions you didn't authorize. California tenant law creates specific, documented obligations with specific penalties for non-compliance, and those obligations don't transfer to your manager, they stay with you. The tools available to self-managing landlords in 2026 are materially better than they were even 3 years ago, which changes the calculus on whether self-management is practical. And if you're going to make the switch, do it deliberately, exit the contract properly, verify your records, walk your properties, and update your legal documents before you take over. The landlords who are firing their property managers in 2026 aren't doing it because they want more work. They're doing it because they finally did the math. Not just on the fees, on the risk they were carrying without even knowing it. Your property, Your liability, your decision, powered by LeaseBase Intelligence.